amendment to the amendment in the nature of a substitute offered by Mr. Engel.
Without objection, the reading of the amendment is dispensed with. The gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. Mr. Chairman, I believe in the right of doctors and hospitals that do not believe in abortion to not be forced to perform those abortions. I think that we in America have freedom, and no one should be forced to do something that in their conscience or morally they do not want to do. But I do think it should be a two-way street. Provisions of current law, both in health reform and in the long-standing church amendment put in by Senator Church many years ago, protect both doctors who do not believe in abortion and those who do. State laws are not preempted, no matter which group they protect. Federal laws are unaffected as they apply to either group. And the church amendment, as is current law and has been current law for about 40 years, protects providers who participate and who refuse to participate in abortion. But this bill changes all that. It changes current law. It changes the balance that we have had for all these many years and creates a one-way street, protecting only those providers who oppose abortion. Again, I respect those providers who oppose abortion, but I also think what's good for the goose is good for the gander. This is very serious, and we shouldn't be protecting one side and not protecting the other side and going against long-standing law. I am sure that there are doctors and nurses who believe that they are ethically bound to provide abortion services when the pregnancy endangers the health of the woman. I'm also confident that there are doctors and nurses who believe that they are morally required to provide a requested abortion to a victim of rape or incest. Yet my colleagues on the other side of the aisle seem to want to protect only one group's conscience and not the others. This seems wrong to me. This doesn't seem like conscience protection. This seems like the government advancement of a particular viewpoint on abortion. And we don't do that in this country. And it's wrong to say, as one of the majority's witnesses did, that this protection is already provided by Roe v. Wade. It's not true, and it's ridiculous. If a hospital fires a doctor because he performs abortions elsewhere, that's not protected by Roe v. Wade. If a nurse is not given a job because she has provided counseling on abortion, that's not protected by Roe v. Wade. If a hospital chooses to provide training on safe abortion methods and is denied a grant as a result, that's not protected by Roe v. Wade. If a clerk outside says to a woman who comes in for an abortion, sorry, we can't do it here, but the hospital 10 blocks away can do it, that person can be fired by the hospital. That's not protected by Roe v. Wade. So we shouldn't protect one group's conscience and criminalize another's. It's not fair and it's not right. We need the two-way protections that exist in current law, and my amendment provides that. We're not even talking about the woman's conscience. You know, we're talking about protecting conscience of doctors or hospitals, and I think the real conscience that should be protected is the woman's conscience, the woman who decides whether or not she's going to have an abortion. But this law, my amendment, doesn't go over that, doesn't talk about that. It just talks about providers and doctors. Both rights should be protected, and I mean that sincerely. No one should be forced to do an abortion. No hospital should be forced to do an abortion. But on the other hand, if doctors want to do it, they shouldn't be penalized just for doing so. And so I yield to Ms. Capps.
Thank you for yielding to me, and I want to agree with your amendment. I believe we have spent most of our time with conscience provisions outlined in this bill, supporting and protecting those who do not want to provide reproductive services to women. And if we're going to include a conscience provision, as Mr. Engel has put forth in his amendment, this just underscores the fact that it needs to protect the other side as well. And we have ample evidence in past years and currently where people who do counsel the options that a woman has before her and or provide services are routinely discriminated against. So this is a sensitive and divisive issue. There are professionals who oppose abortion, but there are also those who believe they are morally and ethically bound to perform those services, particularly when the life of a mother or a woman is endangered. This protection isn't currently offered, as the author of the amendment states, by Roe, and many doctors who do perform services for women have been routinely discriminated against. And I believe it's fair to state, as this amendment does, that protection should be offered on both sides of this very sensitive and a divisive issue. And I'm prepared to yield back to Mr. Engel.
Chair, thanks, lady. The gentleman's time has expired. Chair recognizes the gentleman from Kentucky, Mr. Guthrie, for 5 minutes.
Thank you, Mr. Chairman. This amendment changes conscience protection to prohibit a state or local government from discriminating any health care entity on basis of the entity requires training for abortion, performs abortion, or covers or pays for abortion. And the conscience protections contained in the Pitts bill that we're debating were approved by voice vote without objection in the full committee when they were offered by Mr. Stupak in the last Congress on the debate over health care reform. This amendment would make regulatory enforcement of laws regarding abortion subject to litigation. While the existing health care law prevents preemption of state laws, regulatory enforcement of such laws will be considered discriminatory and subject to litigation. This change could even result in a backdoor Freedom of Choice Act that provides a legal basis to overturn any enforcement of any state or federal laws that regulate or restrict abortion by calling such enforcement discriminatory. The Gosnell situation in Pennsylvania demonstrates that more, not less, regulation and enforcement of abortion providers is necessary. In the Gosnell case, the state failed to do proper inspections or comply with the Pennsylvania Abortion Control Act. Under this amendment, if the health department had investigated the Gosnell clinic vigorously, as certainly was warranted, Gosnell would have had grounds to sue the state. The change is also internally inconsistent. For example, the underlying conscience protections ensure that government programs cannot require training in abortion, thereby discriminating against individuals who are opposed to participating in abortion. This amendment adds a contradictory provision protecting the requirement of abortion training, thus violating the consciousness of any applicant who opposes doing abortions. At best, this will create an ambiguity in the law. I yield back.
Chair, thanks, gentlemen. Are there any other members wishing to speak on the amendment? If not, the question occurs. Shall the committee adopt the amendment? All those in favor will signify by saying aye. Aye. All those opposed, no. No. The noes appear to have it.
Mr. Chairman, I ask for a recorded vote.
Clerk will call the roll.
Dr. Burgess? Dr. Burgess? No. Mr. Whitfield? Mr. Shimkus? Mr. Shimkus? No. Mr. Rogers? Mr. Rogers? No. Mrs. Myrick? Mrs. Myrick? No. Mr. Murphy? Mr. Murphy? No. Mrs. Blackburn? Mr. Gingrey? Mr. Gingrey? No. Mr. Latta? Mr. Latta? No. Mrs. McMorris Rogers? Mrs. McMorris Rogers? No. Mr. Lance? Mr. Lance? No. Mr. Cassidy? Mr. Cassidy? No. Mr. Guthrie? Mr. Guthrie? No. Mr. Barton? Mr. Barton? No. Mr. Upton? Mr. Upton? No. Mr. Pallone? Mr. Pallone? Aye. Mr. Dingle? Mr. Dingle? Aye. Mr. Towns? Mr. Towns? Aye. Mr. Engel? Mr. Engel? Aye. Mrs. Capps? Mrs. Capps? Aye. Ms. Schakowsky? Ms. Schakowsky? Aye. Mr. Gonzalez? Ms. Baldwin? Ms. Baldwin? Aye. Mr. Ross? Mr. Ross? No. Mr. Weiner? Mr. Weiner? Aye. Mr. Waxman? Mr. Waxman? Aye. Mr. Pitts? Mr. Pitts? No. Mr. Whitfield? Mr. Whitfield? No. 9 ayes, 16 nays.
The amendment is not agreed to.